Hello friends, Namaskaram. Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. In today's class, I will discuss one of the most important topic that is concerned with disproportionate of the asset. It is an offense as per the protocol of section 13 subclause 1 subclause E of the PC Act, which in nowadays is known as the offences punishable under section 13 subclause 1 subclause B of the PC Act. The basic difference is that section 13 subclause 1 subclause E is concerned with disproportionate of asset, while section 13 subclause 1 subclause B is concerned with unjust enrichment. There is no difference in the specifications. But the key point is that in both the offenses or in any of them, the allegation of prosecution might be that the public servant is having more asset, more expenditure as compared to the known source of income. And when the notice is served to him to seek the explanation, he failed to provide the specific explanation, and that's why he is guilty. I want to clarify that you are not bound to prove your defense beyond the reasonable doubt. You are supposed to sustain your defense on the point of plausible effect. If your defense is having the plausible effect, in that scenario, you could be succeeded. I want to clarify that whenever there is a search or survey at your house, you got panic. At this spur of moment, you might give certain explanation. Please avoid this thing. If they are doing the search work, ultimately they will serve you the survey report. At that point, you are bound to submit your reply. But you are not supposed to prove your defense beyond the reasonable doubt. Still, you are bound to submit your reply on the point of plausible effect. For example, they do survey at your house and ultimately they found that you are having a car of rupees 5 lakh. As we know that a car is an asset, and simply your defense is that your mother has gifted the car to you. In that scenario, you may internally submit the affidavit of your mother along with the source of income of herself so that your defense could be on the plausible effect. If simply you are going to submit your defense, you could not be succeeded. Submitting defense does not mean a mere defense or a general defense. You must submit the plausible effect in your defense, otherwise you could not be succeeded. As I observed, as I submitted you by giving the example of car. We may take the another example. For example, if the registry of a house is found to be in the name of your wife, your defense is that your wife is earning and even her income is shown in the income tax returns. In that scenario, she is having the proper source of that asset, and apart from that, she is having the known source of income, in consequence of which that asset has been created. So in that way, we could claim the proper immunity and we could submit our proper reply with the proper plausible effect. In addition to this, we must remember that recently Honorable Odisha High Court had given a verdict in favor of accused, which is dated 15th of May 2025. In that case, the court observed that if the income and assets are accounted for, the alleged disproportionate of asset amounts to only 3.46% of the known income. As per the verdict of Honorable Supreme Court, the specification is 1977 Volume 1 SCC page 816. If a marginal excess less than 10% is witnessed, in that scenario, it could not be said that it would be the case of disproportionate of asset. No criminal liability could be imposed or could be attracted against the accused as per the protocol of section 13 subclause 1 subclause E of PC Act. So basically, whenever we are going to submit our reply, also observe that what is the excess. If there is marginal excess, means the excess is less than 10%. In that scenario, we could have the benefit as per the guidelines of Honorable Supreme Court and as per the guidelines of Honorable Odisha High Court. So basically, the entire work is of accounts. It depends upon us in which manner we are going to submit our reply. Even sometimes there might be a case of double counting. For example, you are having 2 lakh rupees in your account. You purchased a car. There might be a possibility that there could be an entry in the expenditure of rupees 2 lakh. And apart from that, there might be an entry in the asset clause also of rupees 2 lakh towards the car. So basically, it is a case of double accounting which is not permissible. So there might be errors of accounting. There might be errors of omission. There might be errors of double addition. So we have to check out the entire case. If we observe that the said scenario occurs, we may submit our counter reply and could specify to the authorities that the accountings are not as per the norms. If the accountings are not as per the norms, and even the principles of income tax act, and even the principles laid down by Honorable Supreme Court and even by Honorable High Court are not observed while doing the accountings, in that scenario we could have the benefit. So simply we could say that there is no presumption against us as per section 20 of PC Act. We have to sustain our defense by submitting a reply based on plausible effect. But apart from that, if the excess is less than 10%, it is called the marginal excess. In that scenario, we could have the benefit as per the guidelines of Odisha High Court and as per the guidelines of Honorable Supreme Court, which I specified to you. So I think that I have specified you the way to contest the litigation of disproportion of the asset. See you in the next lecture. Till then, Jai Hind, Jai Bharat.